And so what I want to share with you tonight are the basics of estate planning. And what I want to make sure is that that because of this type of subject matter, that let me here try to see if I can move the slide forward here, is to make sure that, as you know, I'm not an attorney. I'm a PhD in gerontology. I have a master's degree in finance and have worked with older adults in this arena for, as I said, over 35 years. But the legal work behind the scenes is done always by attorneys. And I wouldn't encourage anybody to make a change to their own plan or take any general information that I take today as a recommendation without checking with their own advisor or professional first. So with that said, I come to this discussion with the praxis of my devout study of aging, which has brought me to the field of gerontology, because I work primarily with people at early retirement and help them through what I call the ages and stages of life. This is some of the most meaningful work that we do. Some of the most important work that we do is help people find clarity and purpose and meaning within their own family's plan. So what I'm going to try to share with you tonight are some what I call famous and not so famous stories of estate planning experiences that kind of illustrate how the process works and how we kind of navigate the arena of estate planning today here in Illinois. So I want to talk, as I said, about why this is important. Want to talk a little bit about how the process works in terms of what the order of law is, and then what can you do and where you start on this journey. So when I talk about estate planning, I want to start by kind of explaining to you what I believe it is. And I say I want to control my property while I'm alive. I want to give the things that I want to take care of myself and loved ones if I become disabled. And then I want to give the things that I have to the people that I want, the way I want and when I want. And I don't want it to cost a lot, if at all possible. I want to save every last tax dollar, professional fee, and court cost possible. So to that end, what I normally try to do is explain in a very basic way and through some of these stories and examples what happens when someone becomes disabled. When they lose either the cognitive ability or the executive function to make their own decisions through either an accident or natural aging. But what happens in that case? And I always try to get people to understand that it's much more logical and understandable than most of us think, because the order of law applies. The normal order of law that we're all kind of familiar with is what drives the train. And that order of law has to do with how accounts are titled or how we own things, okay? So I want to start out with an explanation of what are the four forms of this asset ownership, the most common forms. You can either own property in your own name, sole ownership. There's no one else on the title of your car or the deed of your home. Tenants in common, which is a form of joint tenancy that is not dependent on what we call the rights of survivorship, okay? But rather tenants in common where you have an undivided interest in property. Let me get back here. The screen kind of popped out on me, and so I have a picture of myself here rather than the slides. Anyway, the next form is the one that most of us are most common with, and that's joint tenancy with the right of survivorship, okay? And I think we know enough about that form of ownership to know that when someone passes away and we're a joint tenant, it's the last person alive. More often than not, it's someone that we're related to, but it doesn't have to be. It could be a sibling or a friend that we could own an interest in a business together. And if I died and it was in joint tenancy, when I died, you would own the whole business.
Could it be a business instead of a person?
Sure.
Or
Could be a share.
charity?
Could be a share of stock. Well, a charity would be a difficult thing. A charity might be a beneficiary, because how would you get the charity to act in the interest of the business? Meaning, you know, let's say we're running a lemonade stand. The charity's not gonna show up and help us squeeze lemons and do that kind of stuff. They'll be there at the end, if we were to bestow something on them. But what I'm saying is that normally people buy a fishing lodge. We just had a little cabin together. Okay, let's kind of make it a little simpler than a business. Or we owned an apartment building. We decided we were gonna buy a 2-flat, and we both owned it as a business interest. And it was something that that we put in joint tenancy, knowing full well that when one of us passed away, the other would become the rightful owner of that property.
But the joint tenant is a person, not a organization.
It can be many things.
Oh,
It can be, okay? But you have to think about the logistics of the operation. So, see. Okay, I have controlled the screen back, so let me go back. So the last form of ownership is the trust form of ownership, okay? This is akin to kind of a corporate form of ownership where it's an entity, all right? A trust is a contract between parties. And so the trust form of ownership is what we're gonna spend a little bit of time talking about tonight. But if somebody owns property in their own name and they die, how do we transfer that property? Well, the order of law tells us how we transfer that property. And it means that, and more often than not, if it's an aggregate value of over $100,000, and I'll talk more about this, then it's going to require some form of court order. Whereas your interest in tenants in common would transfer the same way, but joint tenancy or ownership by trust doesn't require any court process. Okay. So what I want to do is take a look at these 4 people and ask what Glenn Campbell and Ronald Reagan, Casey Kasem, and Estelle Getty have in common. And the thing they have in common is they all lost their cognitive ability, and each one of them suffered from a different form of dementia. And the disease dementia ends with death. There's no recovering from it. There is a trajectory for it. And so an interesting statistic that I try to quote is the fact that there's a 50% chance that somebody over the age of 80 will experience some form of cognitive decline. All right. And so the reason that we see these higher instances of cognitive issues is because 20 years ago, people didn't live to the age that they're living to now. It's longevity that's driving a lot of the process that's changed for us as we see people not dying in their 70s, but people over the age of 80 are the fastest growing segment of the population in the United States today. So knowing that this is a risk, it's something that we have to plan for, because I think that while I try to make a distinction between what I call, you know, what is normative aging? Is it normal to have cognitive decline? And the answer is no. I know people at 102 years old that can hold my feet to the fire on facts and figures that we talked about a year ago in ways that, you know, somebody that's 70 can't. So age does not dictate that. We know 70 and 75-year-olds that just set a record, I think, in the 100-yard dash of something like 7.1 seconds. So physicality isn't necessarily completely driven by age. So aging isn't normative. It's not something that I'm saying, oh, if you live past the age of 80, this is going to happen. I'm not saying that at all. I'm saying that I think you need to be aware of the fact that your likelihood that you might experience this, or somebody that you know experiences this, could be something that you deal with in your life. And so then when somebody loses cognitive ability, what happens, and how do we take care of those people? So I want to share with you a story of a friend of mine. And I'm going to share with you several stories, and you're going to think by the end of the presentation, boy, if you're a friend of Jim's, you got a good chance of something bad happening to you. But that's not true. It's just kind of the situation at hand is best illustrated with real life experiences. And so Ed is an aviation consultant. He was a friend of mine. He worked for the city of Chicago for many years. At the time he suffered a severe traumatic brain injury, he was 52 years old. He lived up at about Narragansett and the Kennedy. He lived with his wife, newly married, second marriage, had been married for about 6 or 8 months, and got on his motorcycle one sunny August afternoon to drive down near the airport where his office was to get some paperwork. And on the way home, the rear tire on his motorcycle blew out and he suffered this traumatic brain injury. Well, by the time he, was at the hospital and his wife at that time arrived, she arrived to find that his ex-wife and 3 children were also at the hospital trying to make decisions and dictate care and other elements of what was going to happen, when at that point in time, they really had no standing to do that. And so he had 3 children. He was a kind, generous man. You could see he's kind of a big guy, fun-loving. And so 10 years later, at this point, about 12 years later, he's still married, but as he aged, he had the capacity after the injury of about a 13-year-old or a 14-year-old. He had good insurance and he's well taken care of, but he became very difficult to manage at home. And so eventually he had to be put into an institutional setting. It happened to be far from the family home. He's permanently disabled. And because he was getting aggressive, it was necessary for him to not be in the home setting. I think he had been cared for at home the first, at least decade since his injury. So the issue at the time was that his wife, and he had not done any estate planning, so he had never signed any forms of power of attorney. Well, Illinois law says that a spouse only, not our children, but a spouse can make healthcare decisions, not financial, okay, but healthcare decisions when a person cannot speak for themselves. So in this case, she was allowed to help make healthcare decisions. But the question would be then, okay, how would then one move his 401k? How would you start to manage his finances? Who becomes the payee representative on his disability payment? How do you interface with the covered health insurance coverages? You need a power of attorney in order to accomplish that. So let me kind of share with you what happens when we're incapacitated and we don't have a power of attorney. Well, we're going to take an inventory of all the things that we have, those things that we own, and we're going to go to probate court. We're going to go to the family court. We're going to petition the court for a guardianship over the person and a conservatorship over their assets. Basically, what we're looking for at that point is the court's blessing for us to manage and care for the loved one that we have. But the bottom line is it's a laborious process. I mean, at this point, I don't want to be going to court. I want to be caring for the person that just sustained this injury. And unfortunately, his wife was tied up in court and is to this day. So we had to hire an attorney. To open a probate action, it's generally going to be between $5,000 and $10,000 in my experience, just trying to get a law firm retained to represent you, depending on the complexity of the case. We hire the attorney, and then we ask for permission at that point to care for our own family member, and we're obligated then to report annually. And this was a difficult thing for his wife to get her arms around, kind of why do I have to do this? And that's the order of law. If these simple documents, and so if you learn nothing tonight, but how important having a durable power of attorney for finance, this general power of attorney, and a healthcare power of attorney. So there's 2 separate documents. One governs your body and your health. The other governs your money and your finances. So very important that we have these documents. This is the perfect example of an ounce of prevention being worth a pound of cure, because it really is a simple thing to do. It's not very complex. We need to find the people that we trust the most, and we name these people to safeguard our interests should something happen. And so what I want to ask now, so we've kind of gone through what happens if somebody becomes disabled. I think it's harder than death because the family kind of is going to live through this process twice, right? We lose somebody, we lose them the first time to this process, and then eventually they will pass, and we're going to go through a process again at the end if these things aren't in place. So what I want to talk about now are what these three gentlemen had in common. And we've got Prince, Sonny Bono, and then a man you haven't heard of, but a close friend of mine, Jim Hennigan. And there's Jim Hennigan in the picture. And I want to ask you a simple question here. Does everybody have a will? Okay, well, for those of you that say, no, I don't have a will, the state of Illinois has drafted one for you. Okay, it's called the law of intestacy. And I'm going to explain to you how the law of intestacy works by giving you kind of a firsthand glimpse into what happened when Jim Hennigan passed away, my close friend. Jim is 31 years old at the time of his death. His wife is pregnant, he knows, but did not know that she was pregnant with twins. Jim died probably at this point about 24, 25 years ago. He and I were in high school together at Oak Park River Forest. They used to line us up in alphabetical order. So there was Finnegan, Flanagan, and Hennigan was down the way a little bit. And we became close, fast friends and decided that we were gonna take on the world and try to become real estate moguls. And it worked out for a little while. And we did, we were able to purchase some properties. And so Jim and I bought the childhood home of Jim Edgar, our former governor down in Charleston, Illinois, near Eastern Illinois University. So Jim and I were investing in college real estate before it was popular. Just remember that. And so we had Jim Edgar's childhood home, and I put it in tenants in common, not joint tenancy with the right of survivorship. Well, I did it out of selfish reasons to protect my family. Little did I know, I was really protecting his wife and his unborn children, because under the law of tenancy in common, I had to compensate his wife. I was legally obligated. I believe I would have, as some other friends of ours that didn't have that arrangement did, but I was legally obligated to pay her fair market value for her share of the property, which is the rightful thing to do. So the law of intestacy says when Jim passed away, I want to show you kind of these two slides really refer to the fact that a will of any kind goes to probate court. Okay, probate is the process, it's the public process or the public forum by which assets that we own are distributed. It's a place for creditors and claimants to come forward. It comes out of Old English law, Old Common Law, where, you know, for example, I thatched your roof and you owed me 2 chickens, and then you passed away. I go to the town square and I end up getting the 2 chickens, something like that, in a very simplistic way. But it's become more complex, as you can see from, you know, this slide. This is what the probate process looks like for an executor. It's not just one slide though, it's these 2 slides put together here. So the idea of the state's version of the distribution of our assets and how we would distribute them are very different, okay? So in Jim's case, his children were unborn, he was married, and his parents were still alive, both of his parents. So 1/3 of his estate went to his parents, 1/3 of his estate went to his wife, and 1/3 was put in trust for his child or children. Okay, which didn't help much because we really couldn't access the money until they reached the age of 18. 18 is the age of majority in Illinois. So the idea is that there's a court process, a state mandated process by which the distribution of property and the payment of creditors and claimants is made. It's to create this place, this public place for this to take place. And I say, I don't think this is to help the family as much as it is to help the guy that thatched the roof get his 2 chickens, okay? So not every estate goes to probate, okay? Only some estates go to probate. And the way I want to try to make this come home is by sharing with you the next slide, which says here that $100,000 is the threshold by which we're required to go to probate. So if you have $100,000 of non-probatable assets, so there's 3 non-probatable assets: annuities, life insurance, and IRAs. And those 3 instruments have in common beneficiary designations, okay? So you could have $1 million life insurance policy and it won't go to probate. But if you owned a $150,000 house, it was in your name and you wanted it to be transferred to your children, that would go to probate. Okay, so the idea is that $100,000 or more in aggregate will kind of, this is your ticket to probate, and your will is your engraved invitation. So most people know enough about the process that they're going to replace the state's version with their own. Okay, and they do that by establishing a last will and testament. But the last will and testament then with your will is what you're then required to get filed in the county court to be then the beginning first step process in the probate process. Yes?
What were the 3 items again? IRAs, insurance?
IRAs, life insurance, and annuities. Those are 3 non-probatable assets because they all have beneficiary designation. So a 401k, 457, a 403b, a Roth IRA, those have beneficiaries as well. Okay, and I'm going to talk about how you can put a beneficiary on other types of accounts. And there's a way to put a beneficiary on a piece of real estate as well. You can do this in deeds now. This is rather new, but it's becoming much more popular. And I'm going to talk about the pros and cons of that kind of as we go forward. So we established the threshold at $100,000. If you've got $100,000 or more, there will be a probate action in every county that you own property. So if I own property here in Cook County and DuPage County, and I had a will, there would be a probate action in each county, okay, that property was held. Own property in Florida, it would be the county in which I own the property in Florida. Michigan, same thing. It's going to happen in multiple locations. And every state has a different threshold. The threshold for probate in Wisconsin is $50,000. The highest state in the union is California. I believe that's 150,000, but it's a relatively low number this day and age. And what's the most technically difficult asset to distribute or dispose of? It's real estate. And that's the most cumbersome. That's the thing that takes the longest in the estate settlement that we're involved in. What I want to do, excuse me, is kind of walk you through an example of an estate that we settled. And we settled this estate for a good client of ours whose son had passed away. And so my client was Jeffrey Saylor's mother. And Jeffrey was a Chicago police officer. He had been on the force for 25 years, honorable patrolman, and he died of end-stage renal failure. He was not married, he had no children, and after he loved timeshares, okay? So he loved timeshares, and he tried a lot of different alternative medicine to get various treatments that would, produce some result for him that would help him live a better quality of life and a longer life. And those things didn't work out, but he incurred a lot of debt in this process. And so I want to kind of just walk you through a couple examples of a small estate and what this looks like. And so when I look at Jeff's estate, let's just say, and this is where he was at the time, he had a leased Cadillac Escalade. So he didn't own it, it was leased. So a leased vehicle gets returned to the leaseholder or to the lessee. And, you give them the keys, they're going to sell that vehicle at auction. And when we return this vehicle, they said, well, get the difference from probate court. And I said, okay. he had a bank account with only $3,000 in it. It was in his name only. Okay? And then he had a life insurance policy and a 401k. So he actually had two life insurance policies, a Chicago Patrolman's policy, and he had a Northwestern Mutual policy with a bunch of loans, but everything netted out. And both his life insurance and his 401k or 403b through the city named his mother as the beneficiary. So his mother was able to get the life insurance policies and the 401k transferred to her without any court process. It's simply forms are filled out. They have beneficiaries. The bank account is less than $100,000, right? So what we did was had a small estate affidavit prepared. He had a will that said that his mother was his heir. So we filed the will, which is a simple process. We fill out the small estate affidavit, we go to the bank, and the banker was upset because this was a checking account that had like a credit privilege on it. And he had maxed out the credit privilege, but it wasn't doing payable upon death. But apparently it does something to whatever branch you were at. So it took 2 visits to the bank, but we were able to obtain that money. And then we met after all that was settled. And at the time, she brought in a box of bills, not a shoebox, but like an apple box of bills. And what we ended up doing was we waited for everything to cycle out. We had returned the oxygen tank that he had. The Escalade was returned. All his affairs were closed up. His apartment, the landlord let her out of the lease. Personal property was disposed of. He didn't have a lot. He had a lot of debt. But in this case, there's no forum for creditors or claimants to come. And so then if we don't open up a probate estate, where would these different companies, the timeshares and that go in order to get payment? There is no outlet for them. There is no relief for them. And so in this case, there's really this box of bills. And so we waited a while, and then we set a meeting one day and we went through them, and then we summarily shredded them and we went to lunch and we put it behind us. And that was several years ago. We've settled hundreds of estates, and I knew that there was going to be no recourse to her, and that she wouldn't be responsible for these bills that he had. So clearly there is an order of law for those companies and those organizations to go and get their money. But if you don't have the money to give them, there is no process. So let's just change this situation. And all I did was,
What happened to his condo?
that's what I'm getting to right now. So let's say he didn't live in an apartment. Did you have a question?
Yeah, the Escalade, you said, even though the car was returned, there was still money.
Yeah, so at the end of the day, he owed about $10,000 more than the car was worth.
Did the mother have to pay that or that?
No, that they would go to probate court. They said, we'll see you in probate court. And I said, okay. And then
You don't show up.
there was no court to go to because there was no court process. So now I said, well, what if Jeff, I think about how close some of these things are and how important the knowledge of these laws are. What if he did own a piece of real estate? And in this case, so I add a condo. So now he's not living in an apartment anymore, but he has this condo, but the condo's only got, what do I have there? $20,000 of equity. He owes 190. So you don't take the equity and say it's less than $100,000. You take the value of the asset. In this case, this would have put the whole estate into probate. You would have had no process. So basically in this case, she would have lost the bank account. She would have still gotten, the mother would have still gotten the life insurance and the 401k. Those are driven by beneficiaries, and beneficiaries trump everything. Everything. There are tons of articles and stories. One of my favorites is called The Pension Pickle, where a New York public school teacher had named her sister in the 40s when she first started working for the school district as a beneficiary of her pension plan, worked for the school district for over 45 years. And then when she died, it disinherited her husband. And the sister and the husband didn't get along. And so she prevailed in court and never gave the husband a penny. And that was their retirement. And so it's really important. So you could Google pension pickle and you'll see that New York Times article. So this is just an example of what happens in the probate process. I'm gonna talk about why we try to avoid it, but you know, you could say, okay, I'm gonna just put my kids on the property or on the accounts. I don't need to do anything complex. I'm just gonna add names. And I always look at this as these are kind of Band-Aid solutions. And what happens to Band-Aids? They come off, right? They only last a little while. I was looking at a Band-Aid package the other day and it said guaranteed to stay on for 24 hours. So that was interesting. But the number one issue is people don't understand the tax implications or the liability implications. When you put your child on an account, it becomes, as a joint account holder, it's difficult to then argue that they don't have full free access to that money. So I've seen accounts that where parents put a daughter's name on, get called in divorce proceedings as marital assets. Okay, I've seen accounts where a child was named on an account. They're in some interesting business models, they get sued, and those accounts get pulled right into those lawsuits. If your name is on them and you have access to them as a joint tenant with right of survivorship, then you've got, you know, liability concerns by doing that. There's control issues, because the other thing that I would submit to you is that if I name a child, and I spent a number of years volunteering on what's called the Illinois FAST team, which is a financial abuse strike team that helps intervene when older adults are being taken advantage of, exploited financially by family members or community members or whatever. But the obligation under the law is dismissed to be a fiduciary when I add my daughter to the account. If she's on the account and I have given her full right and signing privileges, she can take that money tomorrow. And legally, she's entitled to it. So even if she does it, I can't get it back, or he does it, it doesn't matter who. So, you know, that's an issue. When people put their, whereas with the power of attorney, you're held under an obligation where you cannot self-aggrandize, you cannot commingle funds. You have an obligation under the law to serve that person's best interests. So if it eliminates the liability issue and creates a standard of care that actually benefits, I'm in a family of 7 Irish people. So you need things like that to keep things really straight and orderly. Yes, ma'am.
If I understand you correctly, you say don't put a child on a joint account, but get a POA, you know, with financial rights?
Correct, yeah. Yeah, as I said, if you named your child and that child became embroiled in some litigation, that would be an issue. If you put your child on a primary residence, okay, let's say you bought your house in Hinsdale in 1970 for $132,000 and today it's worth $1.6 million, your child will inherit your basis. Means where they would have received the property at fair market value as date of death, they now inherit the value that you bought it at. And they will pay a capital gains tax on the difference between the 1.6 million and the 132,000.
So that form would have to be supplied then to your bank, or you would have to have
Of
some
course.
documentation.
Right.
So in case you were away or you became incapacitated, that POA would immediately pick up.
Well, you could do it that way. I wouldn't recommend it doing that way because I wouldn't, you know, what could happen where we need to pay your bills before 48 hours? So if I took a power of attorney, something happened to you, I'm your daughter, and I took the power of attorney over to Chase, either within an hour or two, they're gonna tell me it's approved, or within a day, I'll have full signing authority on that account. So, you know, there's nothing that would require such immediate response that process doesn't. That's when it's necessary and needed. Because before then, what if I go and I litter the world with my power of attorney, and then 5 years later, my daughter gets a divorce and begins to have a substance abuse problem, and I change my power of attorney? I don't want to use these documents till they're absolutely necessary.
Yeah, you have them floating all over and you've changed your mind.
Right, you've changed your mind. So we keep them close to the vest. I don't want to bring my healthcare power of attorney to the hospital. I want the standard of care. I want them to do everything they would do for any reasonable person until and until my life is in question and that I am terminally ill and I'm not expected to recover, and then I'll let my wishes be known. Not before then. What do you think the motivation would be for a hospital to want you to sign one of those forms the morning of the procedure you're gonna have? For your good or for theirs?
It eliminates their response.
I think so too. And so it stands to reason that we want to keep these things private and personal. We want to be prepared, but we want to keep them private and personal.
They always have.
I'm sorry? Okay, the way that you can kind of work around some of this, again, a Band-Aid solution is there are things called POD and TOD. Okay, let's say I have a simple estate where an individual has an IRA. They live in a condo, it's paid for. You could do like I said, a special deed to transfer it to the child or children or parties, doesn't have to be family. You can put these clauses. POD is normally on bank accounts, payment on debt. Or TOD is a transfer on death clause. Those go on securities accounts. So that means that I and I alone have the full right and signing authority on the account while I'm alive. Upon my death, even though it's more than $100,000, my beneficiaries can present, and they will then be given the rights of joint tenancy under the POD clause. But here again, what we've done here is then said, okay, well, if that person became disabled while they were alive, I'd operate the account under power of attorney. And then on death, I claim under the POD. Do you see how some of the things might fall out of bed? You got too many moving parts. There's a simpler way to do this. I'm going to explain this to you. My mother, before she passed, had set up a bunch of accounts for grandchildren. And she put money in banks that were closest to where her kids were. And so when she became ill, was in a nursing home, my sister, younger sister, who was named the trustee or power of attorney at the time, began to consolidate some accounts. And she did this as a financial person. I knew that the first account that she liquidated was the one that my mother set up for her kids to go to school. I said, Maureen, you don't want to do that. I think you want to, pool this money and look at this a little differently, because you've just, in a way, disinherited your children, because that was the account easiest for her to access. Didn't understand the whole plan. You got all these little moving parts. Well, I didn't know that the Schwab account was supposed to go to your brother. We just started to pay for the nursing home, and so we put everything in one. Why does Dad have 11 accounts? Well, because Dad's 86 years old and he's been some places. He's done some things. He's accumulated wealth. These accounts were set up when he worked here. This IRA came from his employment here. These accounts were set up when this happened. This was this bank when he started out with it. Now it's named this bank or this bank. You know what I mean? It's called life. And so it gets complicated. But the way that we can control it, I think, is by looking at what I want to explain to you is the transfer of ownership at death. So we take our assets. The order of law says we have a will. We don't have our own version, the state has one, and we go to probate court. We go to this public process, this community forum, by which then the order of law is going to be applied to each asset. And so it's a time-consuming process, The typical probate estate in Illinois takes between 1 or 2 years. It's closer to 2 now post-COVID. But the minimum amount of time that a probate estate in Illinois must be open is 6 months. So even if it's simple, there's one asset, one heir, and it's known, it still will take 6 months to a year for that process to play out. So it is a time-consuming process. It's public. We lead pretty private lives until the moment of death, and then we're going to take all of our intimate personal information and make it a part of a probate process, which is a public court process. A family member or a nosy neighbor who wanted to look into our business used to need to leave their home, go to a courthouse and look something up. And today I can find 75–80% of the stuff from my desk through websites and through the public information process just to obtain, public records. So there's heir finding firms. This is all a matter of the public record. And so this is how public it is. I liken it to, posting, you take out 3 pieces of paper. On one, you write down everything you own, all your assets. On another, you write down any liabilities that you have. And on the third sheet, you take and write down the names, addresses, and personal information of all your beneficiaries. And then you put that on the Facebook wall. Or in the old days, I would say you put it on that board when you used to walk into the Jewel and they would have those cards up when you walked in the door. That's how I found out my son was cutting lawns, I saw my phone number up on the lawn, up on the wall, we'll cut your lawn. And it was my phone number. I didn't know I branched out, but it's public, that's exactly what this process is all about. We need to send out notices, we need to advertise. So I think the publicity is easily avoidable. It's expensive. And, everybody wants to pick on lawyers. I don't mind if you do. I love them. Some of them are my best friends, but it's not lawyers. It's the process. It's administrative costs. It's appraisals. It's time. It's the things that happen when things aren't done in an expeditious manner. I don't know if you remember a number of years ago, the microburst that kind of blew through the Wheaton area. It did a tremendous amount of damage. We've had some bad storms. And we had an estate open at the time, and a house was pretty severely damaged in this process. And the kids lived out, both of them out of state, and we were assisting with settlement. And this house was in trust, okay? But they were still removing personal property, kind of taking their time. And what happens, this storm comes and does tremendous damage. We had, it was damage to a roof. We had a roofer, a carpenter, a gutter person, a window person, the painter. I mean, there was a branch through the back of the house. It did all kinds of damage, including it took the sensor for the sprinkler system down. And so when neighbors were calling my office 6 months later saying it's raining and the sprinklers are going off, do something about it. I realized, oh, they must have had a sprinkler system. How I didn't know. So the process, though, that we engaged in to help this family clear this out, and this is what I'm talking about cost, was then to go and meet these contractors, right? And the kids live out of state, so if I'm in charge of the project, I'm gonna make sure I get at least 3 bids for each trade, so you can make an informed decision. Has anybody had a contractor not show up for an appointment, let alone to do the job, but show up for the appointment? So I don't know how many hours and billable days were spent trying to put this place back together, but then it couldn't be sold until it was put back together. Time is of the essence, and costs come in all different shapes and sizes and forms. Again, real estate is normally meant to be lived in, right? You need to be there when things happen. When a sump pump goes out, when a pipe bursts. It's important. And so the longer properties are left alone, the more likelihood is that these things can happen and create a cost. The last issue is contestability. The true reason that we're in probate court is for creditors and claimants. It's for somebody to come forward and say, oh, this isn't right. My uncle must have forgot about me. I said, no, your uncle intentionally omitted you. You're the only nephew that he omitted because you're the one that never called, never came, and never participated in anything regarding the family. So it was not an oversight. We don't want to give those people a voice. So after this process of time, contestability, this is where people can argue. This is where people can say that they want to change what you wanted to be done, and you're not there to defend your position. And then I would ask you, what incentive would the law firms that handle these kinds of processes have to handle this in an expeditious manner? They don't. And I've been involved in many an estate where at one point I was accused by a downtown law firm. We had sold a condo out of the Hancock building, and the firm that handled the closing was downtown, and I went through with them where the estate was at, they were asking questions, and it was pretty much done, you know, I had everything set up properly, and it transferred, everything was in trust. And the attorney goes to me, he goes, "You didn't leave a lot of meat on the bone." And I said, "I didn't know I was supposed to leave any meat on the bone." And so, you know, I guess I learned a lesson there about kind of how the system works. The solution, as I've been trying or alluding to, is the fact that it's a trust, it's a living trust. Okay, we need powers of attorney to manage non-trust assets, okay? But if I have this vessel called a living trust, and a living trust is a glorified will. It's a contract between you and your family member, and it's embedded in contract law. Not something that can go away or can be changed. It simply says, I have a plan for how I want my affairs to be managed, a manner and timing in which I've declared, and I've made it known. And then I have begun to transfer ownership of these processes, these properties into this vessel called a living trust. By becoming incapacitated, my trustee can manage all the assets in the trust for my benefit. They have obligations and duties to do so. As a matter of fact, when you establish a living trust, the primary beneficiary of the trust is you. Your children or heirs would be secondary beneficiaries, because it is first and foremost for your use, benefit, and enjoyment. So it is a glorified will. It's also not going to protect you from nursing homes. It does not shield your assets from liability. It acts as a pass-through device. So you don't file your taxes any differently. It doesn't require a separate tax ID number. You will operate very quickly and very easily the same way that you did before, after the process of establishing the trust and funding the trust is complete. I did bring an example of what a living trust package looks like. And I brought the estate planning documents today for Willie Nelson and Angie D'Angelo. Okay, things get a little boring in the office, so we try to make it fun. It could be John and Julie Farmer, but this is kind of what we do. And what I want to try to do is share with you how this should be presented, in what way that what's included in this properly drafted estate plan. It's this living trust agreement. It's a thing called a bequeath of gifts, so we can name items of non-cash and non-real estate to people that are named or not named within our trust. They can be beneficiaries or not. So I might want to leave my Tiffany lamp to my favorite neighbor. So it doesn't have to be a beneficiary in my trust, and that one item would go to that person, okay? Or I could stop my two daughters from fighting over a wedding ring by naming the one that's supposed to receive the wedding ring. Could also give them the wedding ring while you're still alive, too. So there's ways to safeguard it, but it's meant to stop, you know, one from coercing another. It'd be like Dad's tools. You don't want any of Dad's tools. You never did any of that work with him. I did it all, but you're going to use it against me because you know I want the tools. They mean something to me. And we don't want that in the process. We want to try to remove that from an emotional process. We include healthcare power of attorney, a HIPAA release, and an advanced medical directive. That's the triumvirate of healthcare documents. So the HIPAA release is a health insurance portability. It's the privacy form that allows you to grant access to information only. So you could name your children and your spouse to receive full access to all, goings on regarding hospitalization or something like that. They can't make healthcare decisions, not all of them. You would name somebody to, but they would be able to go in and check at the nursing station and get full answers at any time. The medical directive is also known as a living will. So that's when we make our wishes known about whether we want heroic measures to be taken at end of life, whether we want our life to be, preserved under any and all circumstances, or if we do have an injury, disease, or illness that is judged to be terminal by our physician who personally examines you and believes in their opinion that death is imminent, then in that case, then we would then allow that person to die as naturally as possible. And be given any palliative care or comfort care. We include a minor guardianship if there's minor children, a pour over will. So if you have a trust, why do you need a pour over will? And why is it called a pour over will? Well, a pour over will is included with an estate plan or a living trust package because the pour over will is a kind of a safety net under the high wire. You're trying to take this estate over the chasm of settlement. And if anything falls out, the pour over will catches it. So if something was inadvertently left out or purposely left out, that would pour it over into the residuary estate. And that's how it gets its name. So it still would require a probate process. Just had a situation recently where, probably a estate valued at around $2.5 million going from spouse to spouse. Everything settled except for one account an account at Merrill Lynch or something that the husband had not gotten into the trust yet. He changed it to a cash management account. He was there doing the paperwork. He signed all the forms, died unexpectedly. So we got this one account, the wife will get it, but it'll take, like I said, between 6 months and a year for us to get that account into her control. She's got the assets that she needs, but that's a cumbersome process, again, for somebody to be dealing with, when it should be rather simple. So most of these plans, I say, should cost less than $2,500 on average. It's about what I see the average prices around here. I say as you get closer to the lake, it gets a little bit more expensive. I always use an example of a family I met probably at this point, probably 30 years ago, who the only thing they did wrong was have a Hinsdale address. And they were an unincorporated Hinsdale, and they went to an Oak Brook attorney, and they owned a very modest ranch home. But when the attorney saw the Hinsdale address, in 1987, they got a bill for around $4,500. I have a suitcase of these documents in my office if anybody wants to see them, and a copy of the bill. Because he gave it to me, got so frustrated. He said, I didn't understand it. It seemed to be more than our family needed. It was getting way too expensive. The work wasn't getting done. And so he put it in his suitcase and put it away until we met. And then years later, we straightened it all out. And that was the experience. But the experience was that of somebody who had a modest estate, but was then forced to do a really complex arrangement, very expensive and cumbersome. So, yes.
Oh, we have a question from
Yeah,
the chat.
Sure.
It's relating to your prior screen. Someone wanted to know what was the implication that the Chicago lawyer is saying that you didn't leave much meat on the bone with the estate? Did you
Nothing.
want more billable hours or fees out of the estate?
Yeah, they were disappointed that they weren't able to engage in that part of the estate settlement process. Most estate settlements done by financial people, when you think about it, lawyers handle real estate, right? Business interests, things of that nature. But bank accounts are going to be handled by the bankers. Investment accounts, IRAs, brokerage accounts, stocks, bonds. Who does that? The broker, the financial people. The insurance people fill out the insurance paperwork. So why would we pay an attorney $500 an hour to fill out a beneficiary claim form for a spouse?
There's another question as well.
Okay.
Wanted to know, how often do you see it occur where someone makes a bogus claim on an estate during the 6 to 12 month probate period?
How often do I see it? Well, I see avoidable claims made. We don't do a lot of probate. We work really, really hard to avoid it at all costs, but then these things slip in. So like the spousal example that I gave, I don't think we'll see any issue with that. The one that I knew would arise its head, or kind of rear its head, was Jeffrey had an oxygen system through Praxair, and Praxair wouldn't let us return the equipment, and it was all billable. They were even dropping tanks off at the house after they'd been notified of his death. And so literally, his mother had driven from Oak Park down to the south side several times to help get this stuff picked up. And so one day, she and I dropped it off in front of their office on 59th Street. And we never heard another word about it. They got their equipment back, the bills stopped. They would have shown up in probate court. How would we defend the bills that they presented at that point in time? So it's not, error finders, I've come in contact with these error finding services that go and look for errors because there's so much public data. You get a letter saying that there's, a Flanagan that has passed away and that we can't tell you where the estate's located, but if you'll engage us and give us a percentage of what you recover, which is really, then you start, that's when you're like, who passed away? Am I entitled? Am I not? Is this a scam? What is it? That's what I've come in contact with more often than not. And again, when we don't go there, we close the door on all these things happening. It's not public record. This estate gets settled in the privacy and quiet of your home or an office. The forms get filled out, the financial accounts transfer very quickly. And then it's a matter of disposing of personal property and then listing homes for sale, property for sale, disposing them and putting the money in the same account where we're gathering the other assets. We don't need anyone's permission. We don't go to court. We don't publish anything anywhere. And we settle these estates very quietly and very quickly and very inexpensively, I might add. So all of these documents are kind of in that box and included in the plan. I put them in the box because I don't want them in a safety deposit box. These are working documents. They need to be at home. They need to be accessible. Now we digitize everything now and we're in a digital world. So this is changing, but I still live in a paper world and a digital world. And, if somebody knew that was, it pretty clearly says on there that it's Willie Nelson's estate planning document. So if something happened to Willie, you go in that box and that's where we're going to start the process. And so, many times these things happen at inopportune times, right? I haven't driven a document to anybody in years. It's amazing to me how these originals used to be required, wet signatures. Now everything's digital and, we email a PDF, to a bank and an hour later, like I said, the approval for a power of attorney is done. Those records are in place. The key to establishing this trust after you have that box is funding the trust. That's when we take the face page and signature page of the trust and we file it along with the deed of the house, transferring the house from myself and my wife to myself and my wife as co-trustees of our living trust. Or me as an individual to me as trustee of my living trust. So I liken it to like an ambulance, if somebody was driving the ambulance and something happened to the driver, someone else just slides over in the seat and they just keep driving. There's no court process to appoint that. You've already appointed the person, you named them, and you give them powers of appointment to resign if they want and appoint somebody else. So it's really important that it be comprehensive, that it be well thought out, and that it be properly funded. Okay, we work really tirelessly to make sure that each individual asset that somebody has ends up in their trust. So what do these three people have in common? Princess Diana, Warren Berger, Philip Seymour Hoffman. So I'll start with Princess Diana. In Illinois, we do not recognize what are called handwritten or holographic wills or codicils to wills. So anything that you go writing out on a piece of paper and leave won't be honored. Princess Diana left a handwritten codicil to name her godchildren, like 16 godchildren that she had, to be recipients. Would have been about $150,000 or $160,000 each. They denied her request after her death. Her estate did the process, and each godchild got a trinket of jewelry. Not worth very much at all. Warren Berger was the Chief Justice of the Supreme Court, okay, wrote his will himself, and he did not name an executor and didn't have the proper clause to save his family about $450,000 of estate taxes. So his whole process got tied up in court and was the subject of, public scrutiny. Philip Seymour Hoffman goes and uses his real estate lawyer to do his estate plan, and he unnecessarily paid about $12 million in estate taxes. So these people didn't work with experienced professionals, but if you know Frank Sinatra, Liz Taylor, or even Luke Perry, these people had worked with very experienced planners, professionals, had well-crafted plans. Frank Sinatra had his catalog of music and assets down specific to who was gonna receive it, how and when they would get it, what the future rights looked like. Liz Taylor also did an excellent job. We have right now floating on Aretha Franklin, right? Aretha Franklin died, they couldn't find her will. You know where they found it? It was in her couch. It was tucked in the cushions of her couch, but they didn't find just one. I think there are 3 versions of the will floating around right now. They all say different things. One was in a locked cabinet. You know, all these named different people. So that will be in court for a long time, as is Prince's estate. Sonny Bono, I had him on the screen earlier. You got somebody who was surrounded by professionals, advisors, legal people, representatives his whole life. He dies while sitting as a congressman and doesn't have a will. And so his wife at the time couldn't get custody of his body to bury him. It took a process in order to do that. She did, she prevailed, but you know, that's not what most people would want. So work with experienced professionals, and think thoroughly through your plan.
You mentioned earlier, handwritten will codicils are not, legally valid. How about a handwritten will?
No, neither a codicil or a will itself. They have to be properly witnessed and notarized. They have to be initialed on each page, initialed by witnesses. Each state has its specific requirements. Some require a notary, some don't. You know, you'd think that a power of attorney requires a notary, but some states don't. So it just depends on what's valid. Now, what's good to know is that most states are reciprocal. So if I craft a will in Illinois or a power of attorney in Illinois and move to Florida, they will honor that will where I live at the time. They'll honor a power of attorney if it was properly drafted at the time in the state in which I lived. And it's 10 years later, they'll still honor those wishes. They won't say, oh, you moved, you didn't get a new document. Most states are reciprocal. So I say that time is of the essence. It's never too soon to plan. Procrastination is probably the #1 cause of plan failure. So I say, don't wait, put your plan in place. And if there are any questions, we'll take them now.